The justices are people too. Please be seated. We'll hear argument in 240340, Gonzalez against the Texas Medical Board.
May it please the court. Mr. Hughes will present argument for the petitioner. Petitioner is reserved 5 minutes for rebuttal.
What Ray Gonzalez wants is to be able to talk to voters about how his credentials support his public policy without a state agency telling him exactly how he's got to go about doing it, or threatening him with future prosecution, which may deter him from running altogether, or overshadow and swamp the discussion with the voters altogether.
And wouldn't he have been able to do that if he just wouldn't have missed the deadline?
I think the answer is.
I mean, I didn't mean to be abrupt, but isn't that right?
Possibly yes, but he has, and this is our first point, is he has a right, he can bring an as-applied challenge, challenge the agency's authority to do it in the first place, and also whether it's unconstitutional.
Right.
The second is, yes, he could have challenged the order timely, but we argue that it's not a contested case, and therefore the regulation gave him a path forward to sue without complying with the APA deadline for filing judicial review.
Was there any particular reason he missed the deadline? I mean, was he?
Counsel didn't give a reason in the record, but our argument when we first challenged was, you passed a regulation, the regulation says he can appeal, and it doesn't have a deadline. So now you are stuck, that's the path forward, you created it.
So your position is that you say on page 20 of your blue brief, TMB created a right to judicial review independent of the APA, and you cite the Texas Administrative Code section 187.83. How can a state agency create a right to judicial review?
Well, I think the short answer is they cited the statute that authorizes them to write the rules for their own proceedings. And if the legislature has authorized them to write the rules for their own proceedings, and that proceeding is not a contested case and not controlled by the APA, then they can say, okay, you have a right of judicial review. Or they can say, maybe the APA applies, but we're not going to have a motion for a hearing. Well, you don't need a motion for a hearing. Or we're going to dispense with the deadline for filing judicial review. So I think the short answer is, when they enacted this regulation back in 2007, they cited a statute from the legislature that gave them authority to write their own rules for their proceedings. And
did it have a limitations period?
I'm sorry, what?
Did it have a limitations period?
There's no limitations period in the regulation they passed.
So wouldn't that be highly unusual in this type of situation?
It might be unusual. I think there might be other equitable grounds such as latches and the likes, but
would there be general rules that would apply about when you have to file a petition for review that would govern the timing?
Depending on how you phrased your challenge, I think there was some provision in the general statutes of limitations would kick in. And I hadn't considered what one would be the one that might apply. But I think between latches and I believe there's a catch-all limitations period in chapter 15 or 16. If it's not governed by other ones, it's 4 years.
The board says that the Court of Appeals was right about the as-applied claim because you cannot obtain any relief beyond reversal of the order itself. And then I think your position is that we can obtain injunctive relief, that such an order not be entered against your client again. But what is to prevent anyone seeking reversal of an order to bring the challenge that you're bringing, the as-applied challenge, by merely saying, and we'd like an injunction not to do it again? So I'm trying to figure out how we can limit this idea of future injunctive relief against entering an order that you seek to have vacated.
Well, first, that's the bridge I think the court already crossed in Patel. It says the fact that there is a pending agency proceeding, et cetera, is not a bar to injunctive relief to declare the statute unconstitutional. And I think the same would apply to a claim that the courts want that the agency has exceeded its regulatory jurisdiction to do so. Now,
So it's the nature of the constitutional claim that makes this case, like Patel, and different from other cases.
well, it's not
Or that it is a constitutional
substantive
claim.
argument. It's the fact that you're making an as-applied challenge. As applied to me, this is unconstitutional. And I think it can also extend further to the argument, as applied to me, you are exceeding your regulatory jurisdiction. This is not an order you're entitled to make. Now,
So solely with respect to Gonzalez's as-applied constitutional challenge, he is seeking prospective injunctive relief against the enforcement of the Healing Arts Identification Act and the Medical Practice Act as applied to him on the campaign trail prospectively? Okay.
yes, that was it. And in fact, part of his complaint was, I'm about to run for office again, and this is going to come up. And as a matter of fact, it did. But that's outside the record. I'm just saying, he didn't want to have this, he didn't want to face another regulatory challenge or sanctions in the middle of the race.
So does your response to Justice Bland's question mean that that Gonzalez's ultra vires challenge is not covered by the Patel case because the ultra vires challenge is different from a constitutional challenge? Are you conceding that Patel doesn't extend to that?
The argument that they exceeded their regulatory jurisdiction is different than the constitutional claim. But the Austin Court of Appeals, in two earlier decisions, said that you can bring a claim that the agency has exceeded their jurisdiction apart from a challenge to the regulatory action itself.
But we haven't said that, right?
No. And I think that's entirely appropriate because if the agency has no jurisdiction, then it can't throw up its own procedures in the APA to say, sorry, King's X.
Haven't we said for ultra various claims you have to name the individuals and not the agency?
That is one of the problems when you bring a challenge. I mean, you're talking about the Heinrich. The
A whole
Heinrich
series
thing.
of cases, right?
Yes. But to challenge the that would, the Heinrich case applies when you have to sue the individuals because of governmental immunity. But the Austin Court had already said there is a path to challenge the jurisdiction of the agency itself under the Declaratory Judgment Act. And that's what they were relying on. That is, the act gives gives the court jurisdiction, not toward damages, but toward declaratory relief, saying that kind of order you can't enter. That's not a subject matter you're authorized to regulate. And therefore, and then the act has supplemental relief as supplemental relief of an injunction. But the Heinrich would be for cases outside the declaratory, because that requires there to be either a constitutional challenge to a statute or an interpretation. But sometimes, like in the Heinrich cases, it hasn't got to do so much with interpreting a statute or declaring a statute illegal. They're talking about, for example, a regulatory action, the issuance of a regulation. And so that, I think, might be why you might need Heinrich in that case. Now, it is possible, and one of the things that could have been done was to bring a Heinrich-like action to say the board has to set aside the order, we'll sue them directly. But up until now, Austin has said you can do that under the Uniform Declaratory Judgment Act, and jurisdiction is, immunity is waived for that. Now, to get back to the redundancy thing, which I think has been troublesome, an appeal under the APA does not authorize the district court to do anything other than reverse and remand the agency decision and send it back. They can't, the district court can't order the agency to reach any particular decision, can't tell them how to do it. And in fact, in this case, the district court might never have reached his constitutional challenge or his challenge to going outside the regulatory jurisdiction. They might have found some other grounds like lack of evidence, etc., so that they wouldn't have to reach those questions. So it might never have been described. And it doesn't authorize the agency to do this either. What I mean by that is the Administrative Procedure Act does not authorize the agency declare the statute unconstitutional, or its application, in this case, unconstitutional. So all the agency would do is set aside their order. They wouldn't declare the statute as applied or on its face unconstitutional. They wouldn't declare their jurisdiction. They would just dismiss the order, and the agency would be free to bring another action against him later on. Now, our argument that the cease and desist proceeding is not under the APA, it's not a contested case, and the APA's path to judicial review doesn't apply, is simply this. We sum it up this way. The Court of Appeals treated the application of the DAPA as a default. In other words, the statute has to, it applies unless the statute says otherwise. I think that's wrong. Our position is a proceeding is a contested case, and that APA applies for judicial review only if the statute indicates that or says that. It's not a matter of public policy or convenience. You begin with the text of the statute.
Well, it's to me, I mean, if something, looks like a duck, walks like a duck, sounds like a duck, it's probably a duck. And that's what this looks like to me here as far as being a contested case. So what is your argument to the contrary?
Well, it's missing a lot of it because the adjudicative, the statute doesn't say they hold an adjudicative hearing. It just says an opportunity for a hearing, which can be very summary. And in the past, TMB, the board, did have essentially summary proceedings. They changed it only when a district court said, no, you can't do that. And not because the statute requires it, but because they had due process problems. So that's the reason it's in there. Second, it's not adjudicatory. Look what's missing. First thing is there's no pretrial discovery, and they've made that very clear. Under their rule, the only thing you get from the board is the evidence they want to offer, not the evidence they collected. So there's no Brady violation here. They may have evidence exonerating you, but they don't have to give it to you, and you can't find it out. We don't do discovery and depositions and all that sort of thing. The other thing is you don't have a neutral and impartial fact finder. The two members that sat on this were members of the board itself, and the board is not charged with protecting people who are charged with this. The board's mission is to regulate and protect the profession.
Thank you, counsel. Your time has expired.
Okay, thank you.
We'll hear from the respondent.
May it please the court, Mr. Kraft will present argument for the respondent.
Thank you, Mr. Chief Justice, and may it please the court. The Court of Appeals correctly affirmed the dismissal of most of Gonzalez's suit because he filed it months after the APA's deadline for seeking judicial review of the board's order. And the two general arguments you've heard today as to why he was not subject to that deadline are wrong. First, he's wrong to argue that the deadline doesn't apply to some of his claims because they purportedly sought relief that went beyond judicial review of the order. All the relief he's talking about is either barred by immunity, not in his live pleading, or redundant of his claim for judicial review. Second, he's also wrong to argue that the APA doesn't apply here because this was somehow not a contested case and the board's rules provided an alternative path for judicial review. The order and proceedings satisfy the APA's requirements for a final decision in a contested case, and no agency has the power to provide for judicial review independent of the legislature.
But does an agency have the authority to mislead someone that they do and then say, oh, well, sorry, we were wrong about our regulations, so too bad for you?
They don't have that authority under Mosley, but there's a legal and factual distinction from Mosley here. The legal distinction is, one, you don't have a due process claim in this case like you did in Mosley, so that's not before you. Also, it's not, the underlying rule is not misleading because in Mosley the problem was you had a rule that said you must file a suit for judicial review 30 days after you receive the order. That's wrong. You can't do that unless you first file a motion for rehearing and get that ruled on before you can seek judicial review. The rule they're talking about, which is the former rule 187.83, just says, if after the issuance of a cease and desist order, the individual wishes to appeal the entry of the order, the individual may file a petition at the Travis County District Court. That's true. That's just a restatement of what APA section 2001.176B1 says. Now, the agency isn't required to cut and paste the entire APA into its rules. It's simply saying, it's putting a bow on this rule and saying, if you're unhappy with the order, you can seek judicial review. Now, there's also factual distinctions here. The main thing, Justice Busby, is they were not misled. If you look at page 93 of the record, they filed a motion for rehearing. There's nothing in this board rule about filing a motion for rehearing, but they filed one, and that comes from the APA. Now, we know they knew they had to follow the APA because the last page of their motion for rehearing, this is on page 93 of the record, says, wherefore premises considered, comes now Ray Gonzalez Jr. and files this, his motion for rehearing, as required by the Administrative Procedure Act. And when did they file this? They filed it 25 days after the board signed its order. What does 2001.146 of the APA say? You have to file your motion for rehearing 25 days after the agency signs the order. They knew. They knew the APA applied here. So the problem is not anything misleading in the board's order. The problem is not any, or the rule, the problem is not anything about confusion whether the APA applies here. Their problem is that they were following the APA until they weren't. The problem is they stopped following the APA when it came time to timely seek judicial review of the board's order. And all the arguments that you're hearing in their brief are post hoc rationalizations for that mistake. The APA applied here, they knew it applied, and their suit for judicial review is untimely because they filed it months after the deadline.
But does Patel revive the as-applied challenge because they seek relief to protect future conduct from an unconstitutional act of the board?
So that is a correct statement of what Patel says, that if you bring an as-applied challenge to the statute saying, this would be unconstitutional as applied to me in the future, and I want prospective injunctive relief to stop that. That is outside of the scope of judicial review and not redundant. The problem is they didn't seek that here. First of all, as to this as-applied claim, if you look at the record,
They didn't seek what? Not injunctive relief? Not, what is it that they did not seek that takes it outside of Patel?
So there's two things. So first of all, if you look at their live pleading, this supposed as-applied challenge on page 34 of the record, it's in a paragraph that starts, the cease and desist order is a prior restraint on free speech and seeks to regulate future speech in contravention of the Texas and U.S. constitutions. So this purported as-applied challenge is attacking the order itself and not the prospective application of the occupations code more generally. So that's one thing he's missing. And his prayer for relief confirms that, Justice Bland. If you look at page 42 of the record, his live pleading, he's got a list of all the declarations he's seeking. Not one of them says, please declare this statute unconstitutional as applied to me. The other thing that he's missing is the prospective injunctive relief. The only kind of injunctive relief that he sought here was temporary injunctive relief. If you look on pages 39 to 42 of the record, the only kind of injunctive relief he's seeking is a temporary injunction to prevent the board from enforcing its order pending a final hearing on the merits. He does not seek permanent prospective injunctive relief. So he is not like the threaters in Patel. They didn't bring that claim.
TMB didn't file a cross petition for review in this court, is that right?
That's correct, Justice Sullivan.
Do you read the live petition in the district court here as having properly sought prospective injunctive relief for the facial challenge that the Austin Court of Appeals said that Gonzalez could go forward with?
We do not, Justice Sullivan. There's simply no way to read this petition as seeking prospective injunctive relief. I mean, there is a line, as this court said in Boz versus Smith, between liberally construing somebody's pleadings and reading something into them that is simply not there. And reading this petition to seek prospective injunctive relief, it's just not in there. We didn't bring a cross petition for review on what the Court of Appeals said about the facial challenge because, in our judgment, that challenge is dead in the water as soon as we get back. I mean, even if you construe his petition as having brought that, there's no way he's going to be able to show that there's simply no constitutional applications of the HAIA.
We normally try to resolve an as-applied constitutional challenge rather than a facial constitutional challenge if we can. So isn't it kind of backwards to send Gonzalez back and say that courts of this state should only look at the facial challenge here?
It is odd, and our position in the Court of Appeals was that he had not brought a facial challenge either, but we did lose on that. But his live pleading is simply not bringing this as-applied challenge for future relief from application of the HAIA. And then to the extent he says he brought an as-applied challenge as to his past speech, well, that's redundant of the order, because the order encompasses his past speech. So,
Well, he can amend to add an as-applied challenge on remand, presumably, since this is going back.
yeah,
And ask for prospective injunctive relief on that, which wouldn't be barred by because it would be prospective, wouldn't be barred by the administrative proceeding, right?
you're right about that, Justice Busby. He would be able to amend when he goes back on this facial challenge and try to assert a Patel-like claim. Again, it would have to meet all the other jurisdictional requirements, standing, rightness, et cetera. So that's not before you, but yes, I mean, that's
not
for
barred.
another day.
Does he have an ultra vires claim?
He does not have an ultra vires claim for a couple of reasons. One is for the reason that Justice Young alluded to, which is that he sued the board. He did not sue the individual board members.
Could he plead one in this scenario on remand?
No, because, there's a couple of problems with it. So to the extent he's arguing that the order itself exceeded the board's statutory authority, an ultra vires claim would be redundant of that, because one of the grounds for seeking judicial review of an agency's order in the APA, this is 2001.174, is that the order exceeded the board's statutory authority. Or the members exceeded their statutory authority in adopting this order. So that's redundant. Now, he didn't bring an ultra vires claim in this case, and his argument that he can, under these third court of appeals cases that he's alluded to, what he's talking about is the Lumberman's case from 2006, and a case that Lumberman's relied on, the Texas Municipal Power Agency case from 2003. Lumberman's has been overruled. If you pull it up on Westlaw, you'll see the telltale red flag. And the third court of appeals has recognized that case has been overruled, and it was overruled because of Heinrich. Because what the third court of appeals was saying in those cases he's relying on is that the UDJA waives immunity for a declaration to construe an agency's statutory authority. After Heinrich in 2009, that's no longer good law. Heinrich says you have to, if you're seeking relief about an agency exceeding its statutory authority, that has to come in the form of an ultra vires claim against the individual officers and seek prospective injunctive relief, and he didn't do that here.
But could he? I mean, if his position is, this order is just a nullity, I don't really care about the order. What I care about is that I'm going to run for office again in a couple of years, and you guys sure are acting like you're going to nail me to the wall if I do that, and so I want prospective relief preventing you from doing that, irrespective of whether this order about my past actions lives or dies.
Yeah, I think that would be in the bucket that Justice Busby was talking about. It would have to be something that on remand he would have to essentially bring a new claim, that against the individual members of the board, that any application of this statute to him or any proceedings going forward would be ultra vires, and seek prospective injunctive relief, which he has not yet sought, against that. But I mean, you shouldn't remand for the purpose of allowing him to do that, because that's really outside the scope of a remand to cure jurisdictional defects for a couple of reasons. One is that he's already amended once. In response to our original plea of the jurisdiction, which raised redundant remedies, he filed his first amended petition for review. And once you amend once, then if you still don't have jurisdiction, the remedy is to dismiss. We don't let you keep going up and down the appellate chain until you get it right.
Even if his challenge to the order is dismissed with prejudice, wouldn't his challenge to prospective future actions against him be a different case that's not barred by the fact that this case, they already lost this one, and so would it really?
It would be a different case, you're right.
Right, and so would you really worry too much about whether he files it as a different case or whether he files it as an amendment to this petition on remand? I mean, does that matter?
It would be up to him to do that, but it would be a new claim, which is why it's not something that shows error in what the Court of Appeals did, because in addition to he's already had one bite at the apple, in cases like Clint ISD versus Marquez, this court has said that we remand to cure jurisdictional defects only to allow you to plead more facts to support the claim that we decided wasn't within your jurisdiction. We don't remand to allow you to add new claims that would invoke the court's jurisdiction. Now, because we're already going back I can't stop him from doing that, but it's not something that the Court of Appeals erred by not remanding and essentially directing the trial court to let him do that. That's the difference.
It strikes me odd that the Texas Medical Board would be in the business of policing speech on the campaign trail. Has TMB ever done that to anyone else besides Gonzalez, to your knowledge?
I don't know, Justice Sullivan. I don't know the answer to your question. I can find out and submit a letter to that effect.
Thank you.
It does have authority to do this, and the issue of the board's authority, let me be clear, is not an antecedent question to the jurisdictional issues that are before the court. The Court of Appeals did discuss how the board got here, but that was really just regulatory background to give context to its decision. It did not decide the merits. It did not decide whether the board was within its authority or exceeding its authority, but it was acting within its authority. And
Is it unusual for the board to act on the basis of an anonymous complaint?
I couldn't tell you standing here, Justice Huddle, whether that's par for the course or this was a one-off. I don't know. But once the complaint was lodged and they did look into this, they did determine that they had reason to go forward. And I can walk you through the board's process here. I'll start with what I'll call the cease-and-desist statute. That's section 165.052 of the Medical Practice Act. That says the board, after notice and opportunity for a hearing, may issue a cease-and-desist order prohibiting a non-licensed person from violating this subtitle, which is the Medical Practice Act, or later on, violating another state statute or rule relating to the practice of medicine. And here you had violations of both kinds.
What do you think relating to means?
So relating to is very broad. I think that's an expansive term. And the reason why...
Is it so expansive that it would include someone who's speaking about obtaining a job in Congress as opposed to someone seeking to offer services for treating, providing health care to people? It
Yeah.
seems like that's a pretty large distinction.
But it is within the charge that the legislature gave the board, and here's why. If you'll allow me to.
It's hard to imagine that the job of being a congressperson is related to the practice of medicine.
And in accordance with Justice Bland's question, I also am concerned that it didn't seem to me from anything I've read that he was even holding himself out, that I'm here to offer my expertise to help you cure your blank. He was simply using it to run for,
And here's how the board gets there. So, again, one of these violations is within the Medical Practice Act. It's section 165.156, which says a person commits an offense if the person, through the use of any letters, words, or terms on advertisements or in any other manner, indicates the person is entitled to practice medicine if the person is not licensed to do so. So that's one. That's not the relating to part. That's in the Medical Practice Act. Let's get to the relating to part. That's the HAIA 104.004 of the Occupations Code.
Before you get to that, though, just using the word physician indicates to the board that you're entitled to practice medicine in the board's view.
Yes, it wasn't just using the word medicine, though. I think
Physician, I think, is what he said.
It's the context of using physician and the things he said.
The context of I want to go to Congress and change the laws about how we regulate the practice of medicine.
No, it was talking about how he's a doctor, and as a doctor, these are the things that I understand. As a physician, these are the things I understand. I think it's all of that together. It's not just.
What if part of his platform in running for Congress was we shouldn't regulate professions this way? And I went to medical school, therefore I am a physician, and the medical board is an unjust abomination, and that's why I want to go to Congress.
Yeah, I think
Is that different? And then if that's different, then how do you really draw a line and say, well, this congressman can say it, but that one can't?
Yeah, it's all going to be based on context, but the HAIA is a little more specific than that, because that is specifically regulating the use of the term doctor, and this is where we get to the relating to part. That section says, in using the title doctor as a professional asset or in any manner of professional identification, a person other than a person described by section 104.003, which are the licensed people, so in other words, a non-licensed person, shall designate the authority under which the title is used or the college or honorary degree that gives rise to use of the title. Here's why that's related to the practice of medicine. Practicing medicine is a defined term in the Medical Practice Act, and I'm looking at section 151.002.13a. It defines practicing medicine to include treating or offering to treat a disease by a person who publicly professes to be a physician or surgeon. So because publicly
But he
professing...
wasn't doing that.
Yeah, it sounds like you're arguing against yourself.
No, I'm arguing for myself because
I assume you are, but.
because publicly professing to be a doctor is an element of practicing medicine. It's not the whole enchilada, but it's an element of practicing medicine. And because it's an element of practicing medicine, a statute like the HAIA that regulates the manner in which someone may refer to themselves as a doctor is at least a statute relating to the
So
practice
if
of
you're a
medicine.
professor of literature or engineering or any other field, and you're giving a speech and everyone refers to you as doctor, do you need to clarify every time, my doctorate is in engineering from the University of Texas or wherever? Otherwise, you're in violation of the Health Care Identification, Healing Arts Identification Act.
Yeah, I think that's a harder case. And again, we're spending a lot of
I think
time
that's a hard
talking about the merits, but
I mean, a lot of college professors or people with PhDs refer to themselves as doctor without signifying where they obtained their doctorate.
yeah, I understand that, but I think this is, what happened here is really to the core of what the Healing Art
The
Identification
core,
Act
I mean,
is about.
he never said, now let me give you some advice on the kind of vitamins to take or what surgery is good. Do you think that's the core, really?
Well, again, because it's
You've taken the word relating to, which, my clerk gave me a great Justice Scalia quote, everything is related to everything else. And, based on that, which takes us out of the core already, we're now looking at something and say, well, we're using related to get there. I don't think that core is the right word, is it?
well, I'm talking about the core as it's defined in the statute, which is in using the title doctor in any manner of professional identification.
With
period.
respect to someone who wants to prescribe or, given the constitutional issue that is obviously swirling around here, core speech in democracy, persuading people whether to vote for you or not, shouldn't that play a role in looking through this analysis, even as a constitutional avoidance matter, even in terms of thinking about how we're going to examine authority in a particular context, whether a case can proceed?
If the merits were in front of you, that may be something you would have to wrestle
Well,
with.
how about, the parties haven't discussed the Hensley and State Judicial Conduct Commission case, but isn't that at least relevant in the sense that what was at issue was something of such a serious matter of constitutional import that the court said we're not going to be looking at this as if this were the denial of a license to mine some particular kind of mineral and all that kind of stuff. How does that thinking with the constitutional avoidance mentality behind it affect what you're telling us today? if
I
at all?
don't think you're teed up to invoke the doctrine of constitutional avoidance as the case comes to you. So it should not inform the jurisdictional analysis that you have to do here, which is very straightforward. He missed the deadline. He's not seeking any viable relief that goes beyond review of the order. That's it.
Just one more thing, if I may, Chief. I thought you might suggest that the most egregious or, warning-worthy statements might be something along the lines of, I act decisively in the best interest of my patients. Because I thought your argument would be that only a practicing licensed physician has patients, but
That is what I was referring to when I said it, the context in which he was using the word physician and not just physician itself is what informed the board's proceedings on this.
So TMB is going to protect the people of Texas so that if Gonzalez is on the stump and he says, by God's grace, I am a physician and an attorney, I hold a medical degree from Ross University School of Medicine. Like, that's the protection. If he had said that, then it's okay.
Yeah, that is what the statute requires, is again, I know it's political speech, but, you know, the answer is more speech, and that's what the statute requires here, is more speech.
More compelled speech. Got it. Okay.
Any further questions? Thank you, Mr. Kraft.
Thank you.
Mr. Hughes, you have 5 minutes.
The argument that we didn't plead these as-applied claims stumbled at the outset because that was not in their plea to the jurisdiction. What happened in this case was at the outset of the case, they filed a general plain vanilla plea to the jurisdiction, didn't say anything, didn't allege anything. They asked for it to set, and then 3 days before the hearing, they rewrote the plea, or shall we say finally filled in the blanks, and said, we only have 2 reasons. 1, you filed untimely. And 2, all your other claims are redundant. They didn't say all the other claims actually aren't in the pleading. They didn't say you haven't made an as-applied claim. And we certainly argued that. We made it clear, not just in the amended pleading we filed, but when they responded to the temporary injunction, we filed a reply and said, that's exactly what we're saying. We're trying to protect our future conduct. So that's why they can't now argue on appeal that we didn't raise we didn't plead all this. They had their opportunity in the trial court. They didn't raise it then. Under Miranda, they can say, I'm sorry, you haven't stated a claim, and therefore you haven't waived jurisdiction.
Does it make much difference at this point? I mean, the case has never really gotten off of square one. If we remand, they've acknowledged that there are ways for you to bring the legal theories that seem to be at the heart of this case. We remand, you do that either in a new lawsuit or as an amendment to this petition. Doesn't that just kind of
I hope they
get you where
persist
you want
with
to
that.
be, and they've agreed that you can get there? And
Well, once again, if they persist in that with that and concede that, fully conceded that then that's not a problem. We can raise it, but we have. The second thing of it is, I think we disagree a great deal about the purpose of the Healthcare Identification Act. And I think what he's done is lifted a section out of context, and that's section 104.104. What the act was written to do and was intended, when you read the history and the context, it was intended to set out how licensed professionals shall refer to themselves. It was not intended to deal with unlicensed people, because when you read the heading of the act, it said that it was to protect the public by requiring licensed persons to identify the system they are licensed to practice. And that's therefore what you had was in section 104.103, you had a list of specific professions and the designations that they shall use or may use for themselves, which then created the lane for those listed ones. Subsection 104 was not intended to not apply to everybody in the world who might call themselves a doctor. It was intended to apply to the other licensed professions. For example, there was a decision by the Attorney General about acupuncturists. That was Dan Morales, I've listed in a brief.
There's a recent opinion by the 15th Court of Appeals that said the board, in a similar case, didn't meet its burden to demonstrate that the hearing that had the hallmarks of a contested case. This in the Yanutzi case recently. So they said that that was not a contested case. Is this different? Perhaps you think the 15th Court was right, or maybe not, but is this different because your pleading seems to have conceded that the APA applies or potentially applies? Can that be the difference?
Well, I'm not sure whether the Yanutzi case has been filed a petition for review, but I think in that case, nobody raised the issue in the trial court about that whatsoever at all. And the focus in the Yanutzi case was on whether or not they had proved that this nurse who was talking to paramedics about whether they needed to treat her sister who had apparently fainted at a restaurant, whether she was practicing medicine without a license. And they went to great lengths to find what was not found in this order, is that he was actually offering to treat patients or treating them. Because in the Yanutzi case, they went out of their way in great detail, at least the opinion did, to say that first this nurse told the paramedics that she was a doctor, which of course the nurse denied, and that I'm going to take her back to my office and treat her. And they said that was enough to show that A, she held herself out, that she professed, and the second, that she was offering to treat or intended to treat her sister as a patient. That's not this case. And so when he made the remark, which I think you picked up earlier, that remark was not him saying, I'm treating patients now, come to my office, maybe in the past. But to try to say that was him saying, I'm a doctor now, I'm licensed, etc., was a stretch. And when you read the order, the 5 fact findings from the board itself, they only found one reason, one factual reason that he violated anything, and that was he called himself a doctor. They
Your
didn't say.
your time has expired, counsel.
I'm
Your
sorry.
time, thank you. Your time has expired. Thank you, Mr. Hughes. Thank
Okay,
you to
thank you.
all counsel. The case is submitted, and the court will take a brief recess.
All rise.